All right, so this I titled the top 10 most devastating IP mistakes made by small businesses and some quick and easy fixes. After being in this job for a while, we start to see repeated errors. And probably one of the most valuable things that we can do is just to tell others about these errors so they don't run into the same problems. So first off, here's intellectual property, right? And if I could get to the right mode here, this is actually interactive. So we got trademarks, copyrights, trade secrets, and patents. Let's see, JB there. Can you hear me? Oh, you're muted. JB? I can't hear you. All right. Well, anyway, I just want to find out, what's a trademarks? Anybody know? You see them all around, right? It's technically just a word, symbol, slogan, or design. There's other ones. There's also sound and color, but these aren't as common, and you see them everywhere, right? What it does is identifies the source of your goods. So trademarks are always paired with either goods or services. So there's Cadillac cars, there's Cadillac dog food, right? But there's no likelihood of confusion that one would be done by the same source as the other. Nobody believes that a car company would make dog food. So you look at both the name and then you look at the goods or services and see how close they are. Now the name's identical, but the goods and services are much different. So there's no likelihood of confusion, and that's the standard. Now there are state trademarks, but state trademarks, vary by state. And some states, it's an exact match. If you have one letter different, they'll give you that trademark. Much different in federal. And of course, federal will supersede the states. So here's where it comes from. It comes from the Lanham Act. It's, of course, federal law. There's the U.S. Patent and Trademark Office in Alexandria, Virginia. That's where you get a trademark from. However, you get what's called common law trademarks by usage. So as soon as you take a name and stamp it on a product and sell it, you have rights, but you only have rights where you actually sold. If you go through the hoops and you get a registered trademark from the United States Patent and Trademark Office, it's essentially like you sold everywhere in the country and the territories, and it's our territories, as of the date of registration. So there's a case called Burger King v. Hoots. There were two guys, they both said they wanted to be the Burger King. One guy was in Miami, one guy's in Illinois. The guy in Miami, of course, was selling hamburgers, and he called himself the Burger King. So the guy in Illinois. So the goods are identical, the names are identical. Neither one registered. So they both had priority in the areas where they sold. Now, as they get bigger, they're going to overlap, and then there'll be a problem. They never got to that. The guy down in Florida decided he wants to register it. And of course, he didn't know of the guy up in Mr. Hoots up in Illinois. So when he got it, he got everywhere that was not taken already. However, Hoots was the first to use it in Illinois. So he went up to Illinois and he said, listen, stop using it. I have a registered trademark. Stop it. And Hoots says, well, no, I know trademark law. I'm the first in this area. I should win. So who wins? Eric, can you hear us? Your mic's off. Eric? I don't think we have anybody watching. But anyway, everybody falls for it. And they always say the guy in Miami, he's got the registered trademark. No, by trademark law, it's the first to use it in a given area wins. So there's one city in Illinois, they still can't put in a Burger King. One thing that comes up later, whoops, right here, is the strength of a mark, right? Certain marks you can't get a trademark on because they're just common words that we use every day. Then there's the next level, which are descriptive, okay? They may or may not be trademarked, and I could talk to you about that later. Then they're suggested, but here's the top ones, the arbitrary, fanciful, and coined names. So Prilosec is not a name in the dictionary before the drug. It's a made up word. It's a coined name. These are the strongest. This is what we push people to do. A lot of people end up down here with descriptive, and it causes problems, which we'll get into later. All right, what's next? Copyrights. What's a copyright? A copyright is exactly what it says it is. It's somebody has got the right to say who can make copies or not. So when you buy a copy of the Mona Lisa, right? First off, you buy it from someone who has rights to make a copy, okay? The second thing is you don't own the rights to make copies yourself. You can sell what you have, your copy, but you can't make multiple copies. That's the copyrights. Okay, it only covers expressions, very thin, right? Where patents cover like an idea. So let me give you an example. Say I'll give you an idea of a book. An idea of a book would be boy meets girl, boy loses girl, boy gets girl back. Okay, that's an idea. There are thousands of different expressions of that same idea. Okay, let's move on. Copyrights, right? There's both common law copyrights. Okay, that's where you just essentially write something down, you fix it in a tangible medium. So right now, the notes that you're taking, if you're writing notes down, you have rights, you have copyrights in that. If someone tries to come and copy that and sell it, you could stop them without doing anything else, okay? However, you get more rights with statutory copyrights. Statutory, you fill out this form, you pay $45, you send it to the Copyright Office, Library of Congress, and it takes them a couple months, but they'll come back, you get a registration number. Now you have a registered copyright. Now you fall under the statute. We'll talk about this again later here. What are trade secrets? Trade secrets are nothing more than something that's secret and valuable. Right there, secret and valuable. And they're unlike patents, right? Where a patent has a certain date that it starts and a certain date that it expires. You know what country it's in, right? You know exactly what it is. There's a detailed description and you know, there's term expiration, right? And geography. Well, a trade secret has none of that. It kind of starts up gradually and it's really diffuse. Sometimes there's several different ideas and they're not really explained. And they can span over multiple countries. These are what cause litigation, trade secrets. So there's a way that you can actually protect your trade secrets. Well, now there's the Defend Trade Secrets Act that just came out like last year. But there's a few steps you could take to protect your trade secrets, and not only that, be able to enforce them. Okay, patents. Patents are the biggest things. There's three kinds of patents. The ones we're going to talk about are utility. The design are just for the aesthetic look of something. It's a very small percentage of these are design patents. An example would be the curved corners on your iPhone. That was considered aesthetically pleasing, and Apple files a design patent on it. And then they also sued Samsung. I think they won $1 billion, but it was reversed. Plant patents covers non-asexually reproducing plants that you can cultivate. Very small percentage, like 1% of the patents are those. Utility is pretty much what we're talking about. This is the one that covers the way it functions. An invention functions, which could be a process or a machine. You don't have to be a genius to get a patent. You just have to be clever. You have to know where there's a problem and there's no solution. You make up your own solution. Stuff like this. Okay. All right. Now we get to the real heart of what we're here for. Okay. The problems that we have. What happens, I'm just passing on to you what I've learned at different places. And this one was at Tyco. I was with Tyco Healthcare for a while down in Mansfield, Mass. And at that time, Tyco made, oh God, I think it's over 3,000 acquisitions of pieces of companies over the 6.5 years I was there. And as part of it, we had to go in and look at these small companies, and they're usually US manufacturing. And let me move this. And they're 20 and 30 employees. They're on the edge of bankruptcy, and they never had an attorney, never mind an IP attorney. So what we find? Well, we find things. I also have a small practice that we deal with startups and mom and pop organizations and very small companies. So you see this, it happens. Right here, this is an actual case that happened. A friend of mine in Cincinnati, he downloaded a picture from the internet, said free download. You figure, oh, what can that hurt? Puts it on his website. He had a little club that would get together. It was like one of those professional associations where they'd come together and they'd talk about their business. And so they're having a seminar. So he used it for the website for the seminar. And bang, he gets hit with a cease and desist. And you go, how much do you think that would cost? Well, it's statutory. So it's up to $30,000 per image copied. And it's $25,000 for taking the copyright notice off. And if it's willful infringement, it could be up to $150,000. So my guy, of course, says, well, geez, I didn't know. It said free pictures. How am I supposed to know? Well, that's the problem. Intent doesn't matter with copyrights. All you have to do is show, copyrights are great when you're the plaintiff. All you have to do is show that the image was copied and they had no permission. And bang, it kicks in. So what are you supposed to do? You're supposed to try to find the owner of the image and get approval. And you can do this through a search through the Copyright Office, the Library of Congress. It doesn't happen much, but that's what the law actually wants you to do. Now, I know there's some places that you can join and pay money and download stuff. You're essentially working on their assertion that they have the rights to it. Some of these are good, some of these are not. So this happens. This is a common problem we get. All right, what's number 2 here? Let's take number 2. This one happens sort of a lot with very, very small companies like mom and pop. A guy gets an idea. He says, great, okay, I can't do it myself. I need someone to help me. I need an electrical engineer to do a circuit. So he looks for an independent contractor. He finds a guy and he says, well, geez, I know I'm not supposed to make things public. I'm supposed to have a non-disclosure agreement. Well, that's good. He's so far, so good. And he downloads one from the internet. Not so good. And of course, they sign it. And now he says, wow, I can tell you everything now, right? What happens next? The guy says, hey, it'll make it better. He just suggested an improvement. Well, who owns the improvement? Well, it's determined at the time of conception. Well, he just conceived of it, and there's no contract he's under or contractual obligation to keep it secret. So therefore, he owns it. So now what happens is our inventor here, the blue guy, is trying to negotiate rights back for improvements. You can get patents on certain improvements, And so he's trying to negotiate the rights back for something that never would have happened if you didn't tell him. So how do you fix it? Okay, no ownership. Okay. You need ownership clauses in your confidentiality agreements. What's an ownership clause? Well, pretty much what it sounds like. You say, look, I'm going to tell you some information. And this information, you're going to start to see things you wouldn't see normally. Matter of fact, you might even make some improvements. And if you do, you agree to assign all your intellectual property rights and those improvements to me. Some people sharp enough will say, hey, I know what this means. This means that you're going to own everything. And they say, yeah, you're right. And he says, well, I don't want to sign it. Say, well, fine, because I'm going to go to the next electrical engineer down the street and have him sign it. So that's why you always get these taken care of before you tell them anything. This has saved us many times. Okay, ownership clauses. All right, what's the next thing that happened? And feel free to jump in if you have any questions about this stuff. Okay, let's see. This one deals with the trademarks. Okay, some people, trademarks are fairly easy to do. Some people could do them on their own. You have a business owner, he has a trademark and he says, hey, I'm going to file my own trademark application. Fine, okay. Yeah, and he dumps a lot of money into advertising. Now it takes a while. It takes like a year and a half to get your trademark application. Trademarks and patents are examination systems, which means you don't automatically get them. You apply for it, and then they do a search, and then there's an examination, and it goes back and forth, and you can change certain things in your trademark applications and patents. You can change your claims, and eventually, you might come out with something. You may come out with nothing. Okay, so it takes a while, and it goes back and forth. Copyright is different. Copyright is what's called a registration system. And a registration system is whatever you send them, they're just going to say, hey, this is what they sent me, and give it a number. Okay, so your copyrights, you really don't know if a copyright is enforceable until you actually sue somebody on it. And there's certain reasons copyrights won't be enforceable, like there's a requirement that you're supposed to have some degree of creativity involved in it. And they'll say, like, for a picture, say you're copyrighted a photograph. They'll say, well, what creativity? This is a photograph of, downtown Worcester. You'll say, well, there's certain things that went into that photograph. Like, what angle did you take it from? Do you take it from ground level or the fourth floor? Or, if you have a fancier camera, what's your f-stops? What's your shutter speeds? How's your lighting coming in? What time of day did you do it? And there's different things that'll make it. So there is some degree of creativity that goes with these. If it's something that you've copied from someone else, you're not allowed to have it. Or if it's something you substantially copied, there's a big case going on right now with Andy Warhol and Prince, the picture of Prince. And Andy Warhol would take a picture and like change the coloring and background and stuff. And then he'd make 4x5 grid of these. And, that's what Andy Warhol did. But it's going to the Supreme Court, actually. And they're going to find out exactly how much creativity do you need to get this. All right, so let's get back to our guy here. So our guy advertises, and he spends considerable money in it, in advertising. And this happens, right? And then later he files for his trademark. Okay, I had somebody just a couple weeks ago that was using a trademark for 50 years and they didn't register it. And then finally someone else registered it and was trying to stop them, and it caused a big hoopla. But anyway, okay, so he files for it. What happens? Remember, you don't necessarily get your trademark. You're trying to get your trademark. Well, it gets rejected. It's descriptive or geographically descriptive, right? If something describes the product, they can reject it. Now there's a way around it, which you put it on a supplemental register for 5 years. And if for 5 years nobody else uses that or anything close to it, and you continue using it for 5 years, then you could get it. But who wants to wait 5 years to decide if they have rights or not? So, and it doesn't mean you'll get them anyway. You're going to try. So this guy's in a pickle right here. So he's not going to get his registration, probably. And what happens now? Now, if these people know that he can't enforce it, well, they're free to use it. So now they all start living off his goodwill. Oh, sorry. Okay. So they all start living off his goodwill. Anyway, so that's mistake number 3. Okay, number 4. Oh, I'm sorry. Did I?
Hey, Larry, I just want to remind you to be conscious of time. I know we have like 10 minutes left on presentation.
Okay. I'll cut through these quickly. But anyway, what this says is you search your trademark names before you file or start to dump money into it. Okay, and that'll save you from this problem. All right. Mistake number 4, trade secrets confidentiality clauses. All right, so you hire an employee, right? Many people do not put confidentiality clauses in their employment agreements. So what does that mean? Well, the employee gets access to client listings, price schedules, etc. And he leaves and he starts his own business. This actually happened up in Pennsylvania and Allentown, and I had to defend him. and he was the head of sales. And he had this list that he accumulated, and he went, and they just gave him information. And the company, tried to sue him. Well, if they don't treat it like a trade secret, it's not a trade secret. Can't enforce it. So I asked him, I go, did you restrict access to it? Restrict access means like locking a file cabinet and having a log where you have lists of people who take out files electronically. It's the equivalent. You lock the folder and you have a log of anybody who's reviewed them or when. So easy way to fix things. We go into companies all the time. We say, what do you think is your sensitive information here? And then we do this describing, docketing, restricting access. All of a sudden they have $50,000, $70,000 more value. All right, number 5, patents, no confidentiality. Again, you hire an employee, you have no confidence, same thing. You don't have a confidentiality clause. What does this do for patents? Well, the employee gets access to innovations, inventions, and he goes home, he tells his friends. Well, there's no reason he can't, because there's no confidentiality provision. So what happens? We have a 1-year grace period in the US. Many countries have no grace period. So what happens is after the grace period, you lose your rights forever to file on that patent on that invention. So it's donated to the public. So put in confidentiality clauses. Okay, number 6, invention ownership, independent contractors. So you hire some guy, right, an EE to finish. This is like, the inventor has an idea and he hires somebody. Okay, joint development versus sole development. So he develops with you, he does some research and development. He actually adds things that end up in the product. And he might add trade secrets, he might add patentable ideas. And what happens? You start to make money. This guy shows up later and he says, well, I should get some of that money. And it is a problem. This happens. All right, number 7, patent clearance. Company gets a patent on an invention. Okay. Company makes a product embodying the invention. Okay, so far so good, right? Company begins to sell the product. Okay, they start to make money. They get a cease and desist letter. Why is that? Well, getting a patent does not mean you have the right to make and use something. It means you have the right to stop someone else from making and using whatever is described in your patents. There's a separate, patents can go either way. They can be offensive or defensive. So offensive is getting a patent yourself, trying to stop others. Defensive means if you're going to put out a product, you look to see who else has patents that may cover it, and making sure you don't step on those patents, because right out of the gate, you're going to get sued. And patent infringement is very expensive. All right, number 8, patent prosecution. We have some people that file their own patent applications. Great. Okay. Claims are rejected, so they'll get it, and they might get a non-final or even a final rejection. So what happens? They drop the case. They just say, oh, okay, forget it. They lose all their rights forever. Then they come to us and they say, hey, we filed a patent. It's too late now. They'll say, when you get a rejection, you're allowed to amend your claims, make arguments, and resubmit it. And when you get a final rejection, you can do that and ask for reconsideration. But not only that, you can file what's called a request for continuing examination and pay your money. Well, what's the reason for this? Well, they don't want an examiner to be spending time over and over on these people, because they're funded by the filing fees. So if somebody files a single application, they're allowed like a maximum of 3 strikes. After that, they say, okay, file again. So you can file a request RCE and actually keep going. So it's just a mistake. They just didn't know the law there. Final does not mean final. Okay, number 9. Okay, statement of use. Sometimes we get people that'll file their own trademarks, and sometimes they're lucky enough to get them registered. That's good. They're smart enough to know that every 10 years you have to renew your trademarks. But what many of them miss is between the 5th and 6th years, you're supposed to file a statement of use showing that you're still using it. And if you don't, it goes abandoned. We get many of these, and it just, you know, and trademark files are public, so we can actually look and see who's going to come up on one of these. All right, here's the last one, Copyright Clearance Center. Well, there's many more, but the last we're going to talk about. And so somebody finds an article, you know how it goes, and they send it to a bunch of their friends, okay, with public access. They get a cease and desist. And again, they can run 50, 70,000 in legal fees. Put company rules in place, enforce them. Actually, with smaller companies, you don't see this happening much, but with the larger companies, like when I was at GE, we had what's called the Copyright Clearance Center. And they would come in and do an audit, and they'd look at what magazines or whatever we would use and make copies of. And they'd give us a list and give us a price, what a license would cost to do that. Nobody even knows about the Copyright Center, but that's what you're supposed to do. And then once you get a license, you have a list, you say you can make copies of these, you know, these magazines. Anyway, that's it. And I can hand it back. Oops, let's do a summary here. All right. Obtain a license or owner approval before you use PICs. That's for copyrights. It's the first one. These are all the fixes, right? Add ownership clauses to your NDAs. This is simple. It's like a one paragraph. Search trademarks first. Real easy. You could do that at home. Treat as a trade secret. This is something, you know, takes a little time to sit there and explain each, but you docket them and put them in locked folders. Confidentiality clauses, you know, they're very simple. They're only like a few paragraphs. Put them in employment agreements. So when we go to small companies, we look at their employment agreements. Independent contractor agreements, same thing. Clearance, there's always a gatekeeping. You should add it to your company policy before you release a product. Make sure it's clear. Amend claims, make legal arguments. This is usually for the independent people that are doing prosecution on their own. This is again for people who are filing or prosecuting their own trademarks. Just remember, 5th and 6th years, they're going to lose it, and put some rules in place. Okay, I don't know, Zach, do you want?
All right.
Unshare?
I'll take over.
Yep.
All right, thanks, Larry. That was great.
Okay.
And just so everybody knows, there'll be a recording of this meeting sent to them after the meeting. And if Larry permits, we can also send you the slide deck.
Yeah, sure.
And now we will do Q&A. So if anybody has any questions, please do not raise your hand on camera. Please use the reactions button and the raise hand reaction, okay? And I will call on you. If you can't figure that out, you can just shout out, that's fine, or you can write in chat. All right, do we have a first question?
Yes, Active Kinetic. Sorry, I don't know your name, so.
Hi, my name is Andrew. Thanks. Thank you. Basically, you mentioned cease and there's something else that you said there, cease and something. But essentially, what I wanted you to do is just clarify what do you mean by that, and also you said in your last slide it said something about clearances, and I just if you could elaborate on both those things, that would be brilliant.
Okay, yeah, the between the 5th and 6th years for US trademarks, right? You see, what they want to do is they're trying to flush out trademarks that aren't being used. So somebody will file a trademark, they'll use it for a year or two, maybe their business will go bankrupt, you know, or maybe they'll decide they like a different trademark and not use it anymore. So between the 5th and 6th years, they want what's called a statement of use. And usually it's pretty much like an affidavit. It pretty much is like, yes, I swear that I'm still using this. And they want a picture of how you're using it.
Yeah.
That's a specimen. So usually a specimen, and there's a fee for it also. The second one, you said about web clearance. There's patent clearances, and then there's, well, I'll tell you, patent clearance, is that the one you're talking about?
I think so. It was
So-
the last. It was in your last slide. It said clearances, and I wasn't sure what you meant.
Yeah,
by that.
clearances, patent clearances. Yes,
Uh-huh.
we used to do that. There was a gatekeeper who was in charge of that. We had a process, everywhere I worked that manufactured, these were big companies, and they would have, there's a design review, there's a design freeze, there's, all this stuff. And when we hit design freeze, so say like I was with Tyco Healthcare, say we're making a new, I don't know, let's just say a catheter. They're making a dialysis catheter. And they say, okay, here's the way we're going to make it. Here's our design. This is what's good. Because you got to remember when you manufacture, you stamp out thousands or tens of thousands of those, and they're all identical, and then you order the parts. And so once you get it going, you can't change it really. You say, here's the design. And so they'll hand it to us then and say, okay, this is what we plan to put out like 2 months from now or a month from now. And we would go and do a big search, and we'd find out if there's any patents on, the connectors for the dialysis catheters, the ends, the internal lumen, et cetera. And so we do a search. And then if we found something, we'd have to go back to the drawing board with them and say, look, if you put it out, you're going to infringe this patent. I go, and here's a possible workaround. So we brainstorm with the inventors and say, you can't use a single lumen down the middle. Maybe you could use something else. And sometimes it gets so specific, it hinges on a single word. So it might say a single flat lumen. And if it does, single flat divider. And if it does, if you use a curved divider, you don't meet that claim. And essentially you're not infringing. So that's how, we get down to splitting hairs sometimes. And that way, when they make the design change, then IP will stamp it and say, you have a clearance now. On this design, it looks like you won't infringe anything. Okay?
Larry, don't they also call that a freedom to operate?
Yeah,
So-
freedom to operate. Yeah,
Thank you.
yeah. So,
I
yeah, but
have another question if anybody else doesn't. So,
yeah, go on,
Right ahead.
fire away.
okay, so essentially, I've patented. I've got 8 patents pending for, and when I'm in the UK for this energy technology, which works very well, but and it's got multiple applications. Now, I can take this technology and put it within a number of different devices, and it can do the same thing. I can even show you functionality, so you can sort of see right here, any movement makes this light come on, right? It doesn't take very much movement either. So we can use it for like loads and loads of different applications. But what I've protected the technology through 8 patents, different various aspects of it. But I'm just want to get it clarified. I mean, I've had this clarified a few times, but I just want to get it from different perspectives. So it stops somebody from recreating the actual design of the technology, but does it stop someone from putting that technology, within another design? So if they come up with, say for example, there's some sort of, a walker or something like that that you could walk around with, would it stop them from putting my energy design into their product?
You know what, we're gonna have, I guess, we're gonna have office hours here, Tyler, or something. But see, on some of these things, it turns on a word. What we'll do is we'll go through your claims and see what your claims cover. And also we find out what your claims do not cover. Okay. And it's very specific and it's very word, it's related to, that's why there's so much time that is taken to write these claims. And so we'll sit down, we'll go through it. You said you're in the UK?
I'm in the UK. Yeah, I'm in. Let's say I have gone down that patent path already, and I've applied. I put eight applications in. It's very, the actual claims are quite strict in the way they've been written, I believe, and that they're very much, look, this is an energy harvesting device. So I'm guessing if somebody said, look, we're going to use an energy harvesting device within it, then it would replicate essentially what we've already done.
So you could,
But
yeah.
I
Okay.
don't know if I don't know if they can put a blocker patent up that sort of says, right, well, this is our design. So you know, you could put this energy device within it, but this is our external design, which is not really a problem. But I just wanted to know, how does that, you know, do we have any protection there? Is there anything that we can fight back and say, look, actually, you know, we don't really want you to use our you know, our patented technology within your design, even if it's some sort of a blocker patent. I don't know if there's any way of doing that or you know, fighting that
What you could do is you could just, you have my email. It's IP for intellectual property at, and my last name Zale, Z-A-L-E, and law
In the
for law
follow-up,
firm.
I'm gonna have a link to your email in the follow-up email to this too.
Yeah,
So-
and it'll be, yeah. And, you know, just send me stuff and I'd be, because, you know, to answer in a vacuum like this doesn't do you any good. You got to look at it and then, you know, we could see specifically where you are. And, you know, and we can even interface. You have to use IP attorneys out there in England? Withers and Rogers?
I have an IP attorney out here who you know, obviously they put together the actual documentation and paperwork. She's very good, but she's also, you know, I just wanted to get a different, you know, different perspective on things, really, just to really understand,
Sure.
because I'm planning on putting the concept out there effectively into the wide world. And I'm obviously concerned that if I do that, how much control do I lose over that? You know, it's a new innovation. The good thing is that it, you know, the patents were actually came back novel. So they were novel patents. That's how they came back. So as far as we know, every single one has come back that there are no objections. There was one objection on one of them, and we were able to, you know, show that it is actually completely different. So, you know, that negated that
And-
one completely. So
And they have inventive step?
they have a completely inventive step. I mean, basically,
Yeah.
you know, there's nothing like this out there, and it's simple, it's straightforward, it works very well, it's robust. So, you know, it's got a lot of really winning factors about it. It's cheap. Those are the things, you know, it's cheap, it's reliable, it's robust. You know, these are pretty, you know, from that point of view, from what we need, that's got a lot of the winning attributes. But so this is why I'm keen to start putting it out there. In actual fact, I'm thinking of putting out a very cut down, scaled down version of it, so that I don't actually show everybody the completed
Well,
design.
That's what I was
Can I,
going to
can
tell
I,
you.
can
It's-
can I just make a suggestion? Sorry, because there's other questions, other people with questions. I
Sure.
think we should probably do that, and then Andrew, you should connect with Larry outside of this. I also think, you know, just based on what he said before, you don't want to over disclose to the rest
Sure.
of us. So,
I don't think I'm disclosing much, but anyway, you're welcome to go and have a look. You know, Active Kinetic. I've got a few bits on the website, but yeah, no, indeed, Larry, if we could catch up, that would be great on a separate call.
I have secure email and everything's confidential since we're under a duty of client confidentiality.
I realize that. Thank you. Yeah, thank you very much. I look forward to to catching up. Definitely, I'll send you an email.
all right. JB, I think you were next.
Thank you. Can you hear me this time?
Yeah,
Okay, that's good. I figured it out. So my question actually might tie into Larry's a bit. It might, you know, hopefully add some clarification for him. I have a two-part question and clarification for me as well. So one, part A is how specific, or actually how broad, you guys were talking about a lot of very specific examples. How broad can it be? So like my invention, when I submitted it to the patent office, covers you know, a porous substance. So that could be, you know, wood, it could be something grainy, you know, it could be a plastic, it could be,
Well-
you know, probably not rubber.
well, first
And
off, I don't
again,
want,
I'm kind of beating around the horse, so I don't get too specific as well. I don't want to totally disclose. But can we use, the application methodology within the patent and say, okay, well, it's very broad. It just needs to be a porous substance because I actually have multiple uses. And being, an inventor without much money, I can't do specifically this, specifically that, specifically this. I would just end up running myself out of money trying to, apply for patents. So how broad can I be? Do I have to be that specific when it comes to application? And then part two, goes down to trade secrets, right? Which also relates. And, like say, we're adding a novel or a material that, is obviously known throughout the world, but it's being used in a novel way. And or B, can we put a trade secret on the method of production? Like we came up with a
Okay.
new methodology to produce this or to incorporate it into our invention. Can we create a trade secret thereof to help protect our ideas?
Yeah, okay, I'll tell you a few things. Okay, the first thing is, since we're nobody is signing confidentiality agreements on here, right? There's only so much we could talk about here, okay? So again, you could contact me directly and we could get more specific about things, all right? So I don't really want you to go too much into what your invention is if, it'll be considered a publication. Now, how broad? Well, it's kind of like the three bears, not too broad. What happens is you want to make it as broad as you can make it without stepping on what's out there already. And to do that, you have to do a search to find out what's out there. The problem with the search is if you find something close, you have to tell the examiner. So you're in a catch-22. So when people say, should I do a search or not do a search? I'm like, well, it depends, whatever you find, you're gonna have to tell the examiner. So anyway, but the bottom line is, last week I was working on laser cases, yes, 2 days ago I was working on headbands. So they're like the subject matter changes all the time. So we're not experts on everything. So we'd have to go out and do a search and to see what your formulation and what's out there already. Okay, which you should do. You should go to patents.google.com and just type in words and it'll show you the patents that are related, full text with images and everything. Okay.
Well, I'm fortunate, much like Larry was, in that there aren't any results from my area. But I went as far as to and thus the question to look at the application thereof. So like the Trademark Office, I've been in a lot of these webinars, just learning everything I can and absorbing whatever I can. So I went to a few Trademark Office ones, and I'm looking up on there as well. And they're very specific. If you make a brand, it covers a T-shirt. You can't write down apparel, right? So apparel covers the whole broad subject of clothing, whereas a T-shirt is very specific, and that's what the Trademark Office wants to see. So even drilling down into the specific zones of what my technology could be used for, there is nothing there, which is, very lucky, I think. So thank you for that, and I probably will contact you. But for part two of the question, now how, involving a trade secret, how does that break down? Are we looking at, do we want a novel material or novel use of material, or even a methodology of that production of the
there's
invention?
certain substances that have been, I'm trying to think of what it was, but there was a drug and it was used, I think, for headaches, but they found out it had some really other good property. I forget what it was. I think it was something about the joints, stopping wear on your joints. So
it's very, Humira is a great example of what you're getting into. They've extended that like 7 times or something.
yeah, so what I'm saying is that you can have an existing substance that's used, has a new use, provided that the new use is novel and non-obvious. Okay? Now, novel just means whatever the elements of your invention are, A, B, C, and D, that there's not another thing out there, reference we call it, that has A, B, C, and D. So all of them have to be in one reference. Then there's another thing called obviousness, which means A and B could be in one reference and C and D could be in a different one, but it's obvious to combine them. That's the vast majority of our rejection.
Really? Okay.
90% are that way. So anyway, but yes, you could take an existing known substance. Not only that, but you can take existing known elements and put them together. That gets a new and non-obvious usage. And that would be a combination patent, they call it. So it does happen. Now, the other thing I want to get to you bigger, you talked about trade
Well,
secret.
I was gonna say it's 2, and I want to be respectful of people's time, but Eric has had his hand up for quite some time, so
Okay, sorry.
I want to give Eric a chance
back to
to
JB
have
on
a
that.
question, and JB, his email will be in the follow-up to this meeting.
Okay,
Thank you, sir.
Hi.
Eric?
First off, I'd just like to say thank you so much. This has been really, really informative. A lot of information, and it's cleared up a lot of questions. I just want to know, that's kind of a 2-part question. So can you tell me anything about universal patents, like just general information, as well as patent revival?
Okay, universal patents, what do you mean?
I'm not too versed in the subject of patents. I'm actually just doing a little bit of scouting right now in terms of ideation, but I've heard the term thrown around, and I'm not too familiar with what it actually entails or what it means. That's why I'm asking.
Are you sure it's not utility patent?
No, universal.
Universal. Universal means covers many things. I don't know. That's because patents are based on whatever the claims say, and that's what they cover. It's almost like a deed for property. It's very specific on what do you own, because you know how patents are. It's an agreement between you and the federal government. You know, you can keep things, some things as a trade secret, or you could get a patent. And the deal with the patent is, I'll tell the world how to make and use my invention. In return, you give me a 20-year monopoly on my specific, you know, improvement. And that specific improvement is set out in the claims. And it says exactly what it is. So I don't know how you would have, it's almost like having a universal deed. I don't know how that would work either. What was the other one?
Patent revival.
Geez, you came up with 2 good ones I had never even heard of. Patent revival, you can, when a patent goes abandoned, you can revive them. Is that what you mean? Like say
Something
if
like
you're
that, yeah.
prosecuting, or if you fail to pay your maintenance fees, you could revive them. There's 2 different things. There's prosecution is when you file your patent application, and fighting back and forth with the patent office takes about 3 years before you get something or get finally rejected, okay? And during that time, you will get an office action. They'll say you have 3 months to respond, or you can go up to 6 months, but you got to pay fees. After 6 months, boom, it goes abandoned. Then you have to revive it, bring it back to life. Now, with an issued patent, you've gone through this process, you got an issued patent, and they're good for 4, 8, and 12 years. Okay, at 3.5 years, you got to pay your maintenance fee for the next 4 years. If you miss that, it goes abandoned there. And then you go through a process and you got to pay extra fees and penalties, but you can revive it. So I'm not sure if you're reviving a pending patent application or an issued patent.
To be honest with you, I'm just curious. I was actually thinking if there had been any proprietary technologies or intellectual property that might have been abandoned, let's say 100 years ago or so, if it would be possible to revive something like that, or the patents disposed of after a certain period of time. Let's say the initial person who patented their idea died, right? Natural causes even, and you know, time has passed. Is their patent still in existence? Is it disposed of? Is it stored? Like, what happens to it?
Yeah, well, it's called intellectual property. So it's like property. So if a person owned a Cadillac and they died, right, that Cadillac goes to somebody, right?
Right.
So it goes to their successors, usually their children or their wife. You know, it's the same thing with the patents. Their
What
inventorship
if they don't
and
have
ownership.
money though?
They don't
What
have
about
any,
insulin?
I'm sorry, what if they don't have what?
Insulin was patented and given to the public for free, and then someone patented it, and now they charge $1,000 a dose for insulin. I think that's a quote unquote universal, should be at least. But someone revived the patent.
Hmm.
Okay, well, first off, patents are only good for 20 years maximum. So when you file it, right, it takes about 3 years to get one. So you got like 17 years of patent protection. And what was your first question? Somebody died. Okay, I don't know if I answered that, but what, do you want to follow up with a question?
I mean, that's pretty much all I really
Oh.
wanted to ask.
I know what you said. You said if somebody patented something a long time ago and the patent expired and you want to revive, now you only get one shot at it. That's why when we do these searches, we can reject you on things that, you know, were patented in 1940 that are long expired. See, there's two different, when you reject somebody, it just shows that it was known, right? And for something to be known, it could be in a magazine article, could have been a product, could have been an advertisement, a talk, anything, a white paper. Just so happens that patents are published. So it's almost like a magazine. So if it was published, right, and then you're trying to get a patent on it, well, it's already known to the public. Okay, enforcement's a different thing. Enforcement means the patent's got to be active. So patents only last for 20 years. Once they expire, they're gone. So if it's 22 years after they filed, tough luck, you know. That's the patent system. It's trying to get all the technology out into the public. So they give you 20 years monopoly, and after that, everybody can use it. Okay, does that answer it, or
Very
maybe
good.
probably confused it more now?
Thank you.
I was just gonna say, I wonder, so Eric, were you talking about international patents earlier, not universal patents?
No, I understand that there is such a thing as an international patent, but I'm talking more of a universal. I don't know too much about the language that's used,
Yeah.
but I know the term is universal patent, not international,
Okay, well,
right?
Well,
I was doing
I'll
some
go look that
research
up.
and I couldn't really find it.
I've only heard about it. I don't know the details, so I guess I'll have to do some digging.
Then I'll search for that as soon as I get off, but.
Do
that'd be
appreciate
something.
that.
Yeah.
All right, do we have, oh, go ahead.
Did
Do we
anybody
have any
a-
more questions?
Well, you could email them to me too, but you know, now how people have told me about this stuff, you should tell other people too, you know. I'll send you this presentation. Just tell them to watch out for certain things, you know.
We've got one more question here. Active kinetic. Go ahead.
Oh, hi there, guys. I was just wondering, when you said universal patents, did you mean international patents?
Oh, I just said that like
Oh,
a minute
sorry.
ago.
Oh, okay. Sorry.
It's okay. I said the same thing to Eric too, yeah.
Yeah,
He meant universal.
Okay.
You know, it's one thing I should add. Somebody was saying about the cost of patents. Typically, kind of on the average, we're doing about 20 hours for a full patent application, about 10 for a provisional. So that comes out to we're at like 300 an hour. So it's about 3,000 for you know, a provisional, and about 6,000. And what we tell people is, if you're not going to make 6 or 10,000 off it, you know, don't file it. The other thing I wanted to say is about patents and trade secrets. Trade secrets are a way also to protect things of certain kinds of things. Mechanicals, it's kind of tough. You could look at it and figure it out. But you got to remember, it costs a lot of money to file in foreign countries. You can't file, even the big companies can't file in every country. So what are you doing? You're telling everybody how to make and use your invention, but you're only protecting it in certain countries, which means you're giving them a full okay to make and use it in the countries you don't file patents. So a trade secret, you keep it secret everywhere, right? So certain things that deal with like chip structure, software, got ingredients, different compositions. There was one with a guy, he was paving a road and he was using a certain kind of paving material. And he wanted to see how long, and he put it out there, and he actually put it out in public for a long time. And that was considered not a public use. However, there was a guy, this shows you how far back they go, had an invention inside a calliope machine. I don't even know what a calliope is, but inside it had some kind of unique thing, and he left it out. There's a circus or whatever, and they said, "Oh, that was a public use." He said, "Well, you had to take it apart to see the part. You can't see it from the outside." They said, "Well, how do you know somebody didn't come in the middle of the night, take it apart, look at it, put it back together?" So there's case law that goes two different ways, but just trying to show you how trade secrets kind of work. And you want to keep it, you could trade secrets. If you could do it, there's nothing you have to do. You have to just describe it, put a docket number on it, put it away somewhere, but you got to make sure you can't reverse engineer it. If they reverse engineer it, they're free to use it. Okay? That's some aside that you never hear, but that's true. Okay? All right, Tyler, I
Awesome.
don't know, what else you got?
All right. Thanks everybody for coming. Zach, do you want to do some closing words?
No, I just want to thank Larry for, bringing his time and expertise to this. I think it's really helpful. I've worked in the pharmaceutical industry and have dealt with patents a lot and different IP situations. So it's good that everybody's trying to get up to speed on this. So thank you, Larry.
Yeah, no problem. Thank you. I appreciate it, guys.
Awesome. Yep. Thanks, Larry. Bye, everybody.